And I want to express my gratitude on behalf of my organization to organizers for this kind invitation for Amnesty International to express its view on this question. I would like to share with you some brief thoughts on two conventional initiatives dealing with crimes against humanity. The first one is the so-called Ljubljana, the Hague Convention on Cooperation in the Investigation and Punishment of Genocide, Crimes Against Humanity, and War Crimes, a new treaty that was adopted last May in Ljubljana, Slovenia, and whose signing conference will take place in The Hague in mid-February next year. And the second one, which is the title of this short intervention, is on the Draft Convention on Prevention and Punishment of Crimes Against Humanity, which is basically a set of articles drafted by the International Law Commission in 2019, after a period of a drafting process, a discussion and debate process, which took place before, as I said, the International Law Commission. The International Law Commission is a subsidiary body of the General Assembly and is the UN body in charge of the progressive development of international law and its codification. Perhaps you remember that the Vienna Convention on Consular Relations, on Diplomatic Relations, the Convention on the Law of the Treaty, the original Rome Statute, the draft codes on crimes and the international law were all developed in origin, by the International Law Commission and later adopted as conventions. In the case of the Draft Convention on Prevention and Punishment of Crimes Against Humanity, was an initiative of the American member of the ILC in 2013, Sean Murphy, who suggested the idea of drafting a convention on crimes against humanity, since in a way we have the Genocide Convention on the one hand, and we also have the Geneva Convention and the protocols dealing with war crimes, but there is an absent leg, if that expression is valid, which is a convention dealing with crimes against humanity. And that was why the ILC agreed in 2014 to go ahead with this initiative. 3 years later, the International Law Commission adopted provisionally on first reading the first text, gave states a year to make comments, and in 2019, the final text of the draft convention was adopted by the International Law Commission and then submitted to the General Assembly, to the Sixth Committee, for the debate, for the discussion among states and its adoption. The question is that the Sixth Committee only adopts in principle resolutions by consensus, and there were strong opposition by some countries to agree on a new convention on crimes against humanity. But fortunately, last year, states agreed on setting up to resume sessions of the Sixth Committee to discuss in detail all the 15 draft articles. And that happened in April this year and will happen again next April in New York. And the chances then will be that in October 2024, the General Assembly has to decide whether or not, for example, to convene a diplomatic conference for the adoption of this the draft convention, which is the view shared, I may say, by the vast majority of states, while some others are strongly opposed to this idea and want to retain this draft convention in the hands of the Sixth Committee, postponing the adoption of this treaty. I would like to share with you some of the provisions contained in this draft convention and the view of my organization regarding those provisions. One important paragraph in the draft preamble of this potential future convention is a statement that the prohibition of crimes against humanity is a peremptory norm of general international law. That is to say, a jus cogens norm, which are defined in Article 53 of the Vienna Convention on the law of the treaty, and which, by the way, it's a conclusion that the International Law Commission reached several times in the past, including last year, through conclusion number 23 of the rules on peremptory norms of general international law, Jus Cogens, whose special rapporteur was the South African professor Dire Ladi. We are of the view in Amnesty International that it is very important that provision. It would be the first time that in a treaty, that is to say, at conventional law level, there will be a provision stated that crimes against humanity is a peremptory norm of general international law. I remember that Professor Sherif Bassioni used to say that among the consequences arising out the Jus Cogens condition of a prohibition, there is the prohibition of amnesties, audedria judicare, the prohibition of superior orders, universal jurisdiction, and so on and so forth. So we fully support the inclusion in the preamble of a provision related to Jus Cogens' character of the prohibition of crimes against humanity. This draft convention repeats the definition of crimes against humanity in Article 7 of the Rome Statute, which in our view essentially, basically, not fully, but basically codifies the vast majority of recognized crimes against humanity. So it is the right approach, and we support that. However, we have very specific concerns regarding the definition of two crimes against humanity, because they repeat some jurisdictional thresholds contained in Article 7 of the Rome Statute. One regarding the crimes against humanity of enforced disappearance, and the second one on persecution. And I mention enforced disappearance because, unfortunately, drafters decided to add at the end of the definition in Article 7 of enforced disappearance the unfortunate expression with the intention of removing the disappeared person, from the protection of the law for a prolonged period of time. We strongly oppose such an approach and advise the states not to repeat such a definition in the draft convention on crimes against humanity. And the same concern we have regarding the crime of persecution, which again, unfortunately, you know that under the Rome Statute, persecution, a person to be accused of committing the crimes against humanity of persecution should also have committed another crime under the competence of the ICC. But in our case, so persecution is not an autonomous crime, an independent crime. It's a crime that only may be, criminal, arising criminal liability if it is committed in connection with any other crime. And that was, I remember, in Rome, a proposal made by some Arab states plus the Holy See, which were afraid of persecution being, a crime per se, an autonomous one. We fully agree with the decision of the International Law Commission not to repeat the very cryptic definition of gender contained in Article 7.3 of the Rome Statute, because that definition of gender does not fully acknowledge the social construction of the concept and the accompanying roles, behaviors, activities assigned to women and men and to girls and boys. So we agree with the idea of abrogating the definition of gender. Another positive provision that is contained in the draft convention is the non-applicability of statutory limitations, which in civil law countries seems to be a tragedy, because very often tribunals apply statutory limitations. However, the question our concern regarding this draft article is that the statutory limitation, as it is defined in this draft convention, is, a very complex definition. States are obliged to take all the necessary measures in order to abrogate in the future statutory limitations, something on those lines. We prefer a more self-executing definition of the prohibition of statutory limitations, like the one contained, for example, in Article 1 of the 1968 Convention on the non-applicability of statutory limitations to war crimes and crimes against humanity. Something in the lines, for example, of no statutory limitation shall apply to crimes against humanity, full stop. Or like in the Article 29 of the Rome Statute. Another positive provision is the one about the obligation to extradite or prosecute audere audjudicare, which is so far at present containing the Torture Convention, the Enforced Disappearance Convention. In the treaty I mentioned at the beginning, the Mutual Legal Assistance, or the Ljubljana, the Hague Convention on Cooperation and Prosecution of Genocide, Crimes Against Humanity, and War Crimes. And, you know, the obligation to extradite or prosecute imposes a conventional obligations to state parties that whenever they found in any territory subject to their jurisdiction, they are obliged to open a criminal investigation for certain categories of crimes. Of course, they are obliged to open a criminal investigation unless they decide to extradite the person concerned to another state or to surrender him or her to an international criminal court. Some people think that the obligation to extradite or prosecute is a form of universal jurisdiction. Some other scholars think that it's purely territorial jurisdiction. For us, it's not a matter of principle, but we want that provision in the treaty. Another positive aspect of the draft convention is the provision, the review provision of responsibility of commanders and other superiors, which today, unlike in the past, in the first draft by the ILC, now holds civilian superiors to the same standards as military commanders, like in Protocol 1 to the Geneva Conventions. Also, we welcome the provision on the right to consular assistance, which we are of the view that should also be applied to any individual, any foreign national or stateless person deprived of his or her liberty regarding the immigration status as provided in the UN General Assembly Resolution 65/212. We also think that the right to consular assistance should apply to those holding dual nationality. Another provision that I would like to share some thoughts with you is the one on the fair treatment of the alleged offender, which is draft Article 11. And although it is not wrong, the provision, it's in a way poor, it's very weak, and perhaps states may take the example of Articles 55 and 67 of the Rome Statute, rights of the person during an investigation and rights of the accused, as an example in order to enhance, to improve the right of fair treatment of any alleged offender for crimes against humanity. We at Amnesty are of the view that statutory limitations should not apply to civil tort suits or other claims for reparation, which again, not in criminal cases, but in civil cases, is normally a headache because in many countries they are subject to short period of time limitations. I also would like to mention that we are of the view that this draft convention should explicitly contain a provision prohibiting amnesties and other similar measures of impunity, codifying a rule under customary international law. The ICTY, the European Court on Human Rights, the Inter-American Court, the Special Court of Sierra Leone, and the African Commission on Human and People's Rights have repeatedly stated that amnesties are not valid, are not applicable to crimes under international law, specifically to crimes against humanity. We also are of the view that this draft convention should contain a prohibition of military courts. All persons suspected of criminal responsibility for crimes against humanity, in our view, should be brought to justice before ordinary civilian courts, to the exclusion of any exceptional competence, in particular military courts or military commissions. We are also of the view that this draft convention should be improved in aspects related to victims. For example, the Mutual Legal Assistance Convention adopted in Ljubljana contains an innovative provision, Article 81, based on Rule 85 of the Rules of Procedure and Evidence of the International Criminal Court, which defines the concept of victim, including natural persons and organizations or institutions as well. And finally, to conclude, we are of the view that the draft convention lacks an important provision that could be inspired into Article 29 of the Vienna Convention on the Law of the Treaty, which is related to federal states, is on the territorial scope of the convention. We think that the new convention should incorporate a provision whereby the new treaty shall be binding upon each party in respect of all places under the state and its various components jurisdiction. We remember that in the past, some federal states did their best to excuse of complying with the International Court of Justice decisions, binding decisions, excusing themselves on the federal structure of the country. So the new convention should repeat the terms of Article 29 of the Vienna Convention on the Law of the Treaty. Well, those are some thoughts that I wanted to share with you about one of the priorities today for Amnesty International, which is the draft convention on crimes against humanity. Thank you.